Hello, I'm Ramya, an associate here at Lakey Family Law. When a couple that's in the process of separating can agree on how they're going to split their assets or care for their kids, it really is ideal for everyone. But often in these situations, the agreement doesn't get legally documented. As family lawyers, we see this come back to bite people months or years later. As time goes on and you both move on with your lives, what made sense at the time doesn't always make sense months or years later. If the agreement isn't legally documented or binding, there's always potential for one person to make an application to the court regarding the parenting arrangements or the division of the assets. And if they do, the value of the asset pool could be based on the current value rather than the value at the time of separation. There have been cases where someone has inherited a large amount of money post-separation and their ex has been able to lay a claim on it because their original agreement wasn't legally binding. And other cases where people have racked up heaps of debt, filed a property settlement, and had that debt included in the asset pool. For parties involved, having to go through the process all over again, often in a hostile manner, can be incredibly stressful, especially if the end result isn't favourable for them. But it is entirely preventable. All it takes is for the agreement to be legally documented through consent orders or a binding financial agreement. Consent orders are documents that are prepared by a family lawyer on behalf of both parties. They detail your property and or parenting agreements and are filed with the court. The process of preparing a consent order is very easy, straightforward, and cost-effective, and nobody needs to attend court. However, they can take some weeks to be processed and enacted by the courts, and in some instances can be questioned by the courts if not considered a fair agreement. A binding financial agreement, or BFA on the other hand, is a private agreement that details your property agreement. For a BFA to be valid and legally binding, each person must have independent legal representation, unlike a consent order which can be prepared by a family lawyer on behalf of both parties. BFAs are typically faster to finalise as they aren't filed with the courts. They're ideal for property settlements in instances where the time out period, which requires property proceedings to commence within 12 months of divorce or 2 years after the breakdown of a de facto relationship has passed, as leave is not required by the courts. While it's understandable that some are reluctant to engage a family lawyer when they've been able to reach an amicable agreement, it really is advisable. Even if you document the agreement yourselves without legal advice, the reality is it is unlikely to be legally binding should one of you change your mind. So it is well worth taking the extra step and getting a family lawyer to document your agreement so you can both get on with your lives knowing your separation is final. At Lakey Family Law, our focus is squarely on helping clients move forward with their lives. We have a great deal of experience advising, supporting, and guiding clients through the process of documenting their property and parenting arrangements. If you and your ex have reached an agreement, we would be delighted to assist you in documenting it so that you can both move on with your lives.